This is the judgment in the appeal in the case involving Sainsbury Supermarkets and Visa Europe Services LLC, and Sainsbury Supermarkets and others, and MasterCard Incorporated and others. The appeal concerns whether certain rules of the Visa and MasterCard payment card schemes have the effect of restricting competition in breach of Article 101(1) of the Treaty of the Functioning of the European Union and equivalent national legislation. The appellants, Visa and MasterCard, operate four-party payment card schemes. Under these schemes, issuers, generally banks, issue debit and or credit cards to cardholder customers, and acquirers, also generally banks, provide payment services to merchants such as the Respondents. The scheme operator, Visa or MasterCard, sets the rules of the scheme and allows institutions to join as issuers and or acquirers. The scheme rules provide for the payment of a default interchange fee, known as the Multilateral Interchange Fee, or MIF, on each transaction which is payable by the acquirer to the issuer. Though under the rules, acquirers and issuers are not required to contract based on the MIF, in practice they invariably do so. The MIF is passed on in full by acquirers to merchants as part of the Merchant Service Charge, MSC, the acquirer's charge for providing services to the merchant enabling acceptance of the cards. For most of the claim period, the MIF typically accounted for some 90% of the MSC and was non-negotiable. Negotiation between acquirers and merchants was limited to the balance of the MSC and the level of the acquirer's margin. These proceedings concern the effect of MIFs on competition in the market between acquirers and merchants. Article 101(1) prohibits agreements between companies that may affect trade between member states and which have as their effect the restriction of competition. Article 101(3) provides for an exemption where the agreement improves the production or distribution of goods or promotes technical or economic progress while allowing consumers a fair share of the resulting benefit. These provisions are reflected respectively in sections 2 and 9 of the Competition Act 1998, the 1998 Act. The Visa and MasterCard schemes have previously been subject to scrutiny by competition authorities. In a decision dated 19th December 2007, the European Commission decided that the MasterCard MIFs applicable within the European Economic Area breached Article 101(1). MasterCard's application to the Court of Justice of the European Union for annulment of the Commission decision was dismissed by a judgment of the General Court. MasterCard appealed this decision to the Court of Justice, which gave judgment dismissing the appeal, MasterCard CJ. The present appeal relates to three sets of proceedings. First, proceedings brought by Sainsbury Supermarkets Limited, Sainsbury's, against MasterCard before the Competition Appeal Tribunal, the CAT. Secondly, proceedings brought by Asda Stores Limited, Argos Limited, and Morrison Supermarkets plc, together AAM, against MasterCard before Mr. Justice Popplewell in the Commercial Court. Thirdly, proceedings brought by Sainsbury's against Visa or before Mr. Justice Phillips in the Commercial Court. The claim against MasterCard before the CAT succeeded, but the claims against MasterCard and Visa in the Commercial Court failed, but for differing reasons. The appeals in all three sets of proceedings were heard together by the Court of Appeal, which overturned all judgments given below. It held that there was a restriction of competition and made various rulings as to the legal effect of Article 101(3). The Court of Appeal remitted the Article 101(3) exemption issue in all three sets of proceedings to the CAT, for reconsideration in the light of the legal rulings it had made. Visa and MasterCard seek to appeal the Court of Appeal's decision on 4 grounds. AAM seek to cross-appeal against the order for remittal. In its judgment, the Supreme Court unanimously upholds the conclusion of the Court of Appeal that the MIFs infringed Article 1011 and its main legal rulings on Article 1013, dismissing the appeal on all grounds except what is referred to as the broad acts issue. The Court allows the cross-appeal. The full Court gives the judgment. Visa and MasterCard appeal on 4 grounds. The first ground is whether the Court of Appeal was wrong to find that there was a restriction of competition in the acquiring market, contrary to Article 1011 and equivalent national legislation, the restriction issue. This raises 2 issues. First, whether the Court is bound by the MasterCard CJ decision, and secondly, if not, whether that decision ought to be followed. The Supreme Court concludes that the essential factual basis upon which the Court of Justice held that there was a restriction on competition in MasterCard CJ is mirrored in these appeals, and that MasterCard CJ is binding, as the Court of Appeal held. Even if the Court were not bound by MasterCard CJ, the Supreme Court would follow it and conclude that there was a restriction on competition in the present cases. The effect of the collective decision to set the MIF is to fix a minimum price floor for the MSC. That minimum or reservation price is non-negotiable. A significant portion of the MSC is thereby immunized from competitive bargaining and is determined by collective decision rather than by competition. By contrast, in the counterfactual, in which there is no MIF but settlement at par, the whole of the MSC is open to competitive bargaining and determined by competition. The Court therefore dismisses the appeal on the restriction issue. The second ground is whether the Court of Appeal erred insofar as it found that Visa and MasterCard were required to satisfy a more onerous evidential standard than that normally applicable in civil litigation in order to establish that their MIFs were exempt under Article 1013, the standard of proof issue. The Supreme Court considers that the essential complaint made by Visa and MasterCard here does not relate to the standard of proof, but rather to the nature of the evidence required to meet the standard of proof in this context, and, more specifically, the type of evidence needed to establish that the benefits from the MIF rules under consideration outweigh the detriments to merchants. In the Court's view, Article 1013 imposes requirements as to the nature of the evidence that can discharge the burden to establish an exemption under that provision, which is imported into domestic competition law by the 1998 Act. Cogent empirical evidence is required to carry out the required evaluation of the claimed deficiencies and benefits. The Court therefore dismisses the appeal on the standard of proof issue. The third ground of appeal is whether the Court of Appeal was wrong to find that in order to show that the consumers receive a fair share of the benefits generated by the MIFs to satisfy the test under Article 1013, Visa was required to prove that the benefits provided to merchants alone as a result of the MIFs outweighed the costs arising from the MIFs without taking any account of the benefits received by the cardholders as a result of the MIFs, the fair share issue. The Supreme Court holds that the Court of Appeal arrived at the correct decision, albeit by different reasoning. The best available guidance from the Court of Justice on the application of the fair share requirement is the opinion of the Advocate General Mengozzi in MasterCard CJ, which considered that the fair share of the benefits must be received by the consumers in the same market. The Court therefore dismisses the appeal on the fair share issue. The fourth ground of appeal is whether the Court of Appeal erred insofar as it found that a defendant has to prove the exact amount of loss mitigated in order to reduce damages, the broad acts issue. This issue relates to the degree of precision required in the quantification and mitigation of loss, where a defendant to a claim for damages arising out of a breach of competition law asserts that the claimant has mitigated its loss through the passing on of all or part of an overcharge to its customers. In the UK, passed on is an element in the quantification of damages that is required by the compensatory principle applicable to the present tortious claims, and required to prevent double recovery through claims in respect of the same overcharge by a direct purchaser and by subsequent purchasers in a chain. The degree of precision required in the proof of the amount of loss passed on involves striking a balance between achieving justice by precisely compensating the claimant and dealing with disputes at a proportionate cost. The Supreme Court does not interpret the Court of Appeal as having held that the defendants had to prove the exact amount of the loss mitigated, but insofar as the Court of Appeal required a greater degree of precision in the quantification of pass-on from Visa and MasterCard than from the merchants, the Court erred. As a result, the appeal succeeds on the broad acts issue. The cross-appeal relates only to the AAM proceedings. AAM submit that the Court of Appeal erred in remitting the AAM proceedings for reconsideration of the exemption under Article 1013. Despite reaching the correct conclusion that MasterCard's defence based on Article 1013 should have been dismissed, the Court of Appeal made an order remitting the AAM proceedings to the CAT, alongside the other two sets of proceedings, for reconsideration of whether MasterCard's case under Article 1013 should have succeeded in whole or in part. In the Supreme Court's judgment, the Court of Appeal was wrong to allow MasterCard to reopen this issue, which it had lost after a full and fair trial. It offends against the strong principle of public policy and justice. There should be finality in litigation. Accordingly, AAM's cross-appeal is allowed.